Asylum seeker visa extension. Pending the decision on the asylum application. The extension of an asylum seeker visa must be made at the Refugee Reception Office where the application was submitted. However, in Nbaya, the Western Cape High Court ordered Cape Town RRO to renew or extend asylum seekers Section 22 permit even though the permit holder had originally applied for asylum at a RRO other than CPT. An application for asylum will be deemed to be abandoned if the asylum seeker did not renew his or her asylum seeker visa within 90 days after it has expired, provided that the asylum seeker advances valid reasons for the non-renewal of the asylum seeker permit. Abandoned asylum seeker. The abandonment provisions provided that in the event that an asylum seeker fails to renew their asylum visa timeously, their applications for asylum are deemed abandoned. Arrest and deportation would follow for individuals with valid and undecided claims for asylum, back to countries of origin where they could face death, torture, sexual violence from which they originally fled, or to countries experiencing grave disturbances to the public order. Only where an asylum seeker has a compelling reason for delaying to renew a permit following a lapse such as hospitalisation can the DHA pardon the late renewal. This is deeply problematic as it means that refugees can be returned to face persecution, without ever having the substantive merits of their asylum application determined. It also leaves asylum seekers vulnerable in SA as essentially undocumented foreigners who will struggle to access health care, employment and education while they await the decision of whether their reason for late renewal meets the DHA high threshold. The reality for asylum seekers is that they are frequently required to renew their asylum visas. In the renewal process, they experience extraordinary delays caused by the administrative failures of the DHA. These are often exacerbated by socio-economic factors, such as not having the means to travel to faraway refugee reception offices as frequently as is required, waiting in long queues at the refugee reception offices, facing corruption from officials who refuse to renew visas without bribes, or the general inefficiency of the refugee reception offices that are overworked but understaffed. In January 2020, legal practitioners expressed deep concern over the Refugee Amendment Act, which came into force on 1 January 2020. This act came into force upon the signing and gazetting of the refugee regulations. Several aspects of the new law undermine asylum seekers' and refugees' rights. Of particular and urgent concern are the so-called abandonment clauses. We are challenging the constitutionality of Sections 22, 12, and 13 of the Refugee Amendment Act and Regulation 9 of the Refugee Regulations. The Refugee Amendment Act also prevents that person from reapplying for asylum in South Africa, which seems to run against international refugee law.